So this is the final panel of the day, and the focus of the panel is on the coordination, the transnational coordination. I like the term coordination rather than regulation, but of generative AI. And we're really happy to welcome Angela Zhang, who will hopefully be with us here at NYU in the fall, teaching. And she's joining us remotely from the University of Hong Kong. And Angela's going to talk about the Chinese moves to regulate generative AI. And also to my right is Mark Rotenberg, who was spoken of in glowing terms by Ambassador Stavros Lambrinidis. And he's at the Center for AI and Digital Policy in DC, and will be speaking about the US approach. And then our own Yurong Sung, who's at the Guarini Center for Global Law and Tech here. And she will be responding to Angela's comments, but also talking about infrastructural approaches and global administrative law approaches, these sort of homegrown NYU approaches to global regulation. So many thanks to all the participants, and let me turn it over to begin to Angela, Angela Zhang.
Thank you very much for having me. I hope you hear me okay. Yes?
Yes.
Fantastic. Yes. So, yeah, just 2 weeks ago, China promulgated its draft measures to govern the generative AI technology. And this set of guidelines were released by the Cyberspace Administration of China, which is China's internet watchdog. And it gives 1 month for public consultation. And we noticed that at the end of the guidelines, they indicate that the draft measures, the measure will be released by the end in 2023. So we expect that China will have these measures out in a few months. And the law is very brief. It only contains 21 provisions and it sets a very general guidance. And because it's promulgated by the CAC, so it's important to bear in mind, this is only a departmental rules. And it's not a national law. It's not a law of very high hierarchy. So it only reflects the position coming from one single department within the Chinese administration. And obviously, because it's very brief, it leaves a lot of room for interpretation. A lot of provisions are quite vague. But overall, I see this I see the CAC being very ambitious and very proactive in regulating this sphere, because China is also a major power in AI technology. But I expect that the regulatory ambition of the CAC is likely to be constrained to some extent, to a great extent, by also China's own ambition to become an AI superpower. And because if they regulate too much, it might stifle China's innovation in this area. So my opening remark will focus on 3 major areas. First, we look at what are the similarities between Chinese regulation and the regulation you see in other major jurisdictions like the EU. And second, what are the differences? And lastly, what are the major controversies in the current draft guidelines? So first of all, let's talk about the similarities. I do see the CAC express quite similar concern as other jurisdictions over issues such as discrimination. So when we look at Article 4 of the draft measures, it prohibits service providers to discriminate in terms of the design of the algorithm, the selection of the training data, and the model generation to provide services. And also Article 12 of the law prohibits providers from engaging in content generation that is discriminatory. And similarly, the CAC is concerned about the prevention of IP, concern about potential IP violations. Article 7 of the law requires the training data should not violate IP rights. So it shows the agency is concerned that the generative AI could be exploiting the work of original content providers. And lastly, it's concerned about data compliance. As you know, China promulgated its major personal data law, the Personal Information Protection Law in 2021, and that is China's GDPR. So Article 7 requires providers of this technology to satisfy data compliance obligations, and they will need to obtain proper consumer consent. And I believe in the case, in the scenario where the services involve cross-border data transfer, they would need to satisfy separate security assessment requirements. So these are the similarities that China has with other jurisdictions. And I will now move on to talk a bit about the kind of distinctive features you see in the current draft. First and above all, you see a great emphasis on political alignment. And that's not surprising, as you see in every single legislation that is churned out by the CAC. Being a content regulator, it needs to make sure that the content that's generated from this technology embodies socialist core value and do not contain any information that is deemed politically incorrect. And secondly, this is something that is very interesting. There is a great emphasis on correct information. The law emphasized that the service provider need to take proper measures to ensure that the content generated is true and accurate. And also you see Article 5 place great burden on the providers of this service and technology to shoulder the responsibilities as the content providers in case of inappropriate content. So that leads to the major controversies in the law is that, how could you ensure that, for these service providers that these content generated is true and accurate? As we know, based on my limited experience using the ChatGPT, 99% of the time, the content generated is not true and accurate. So it's extremely burdensome for Chinese AI companies to be able to fulfill this requirement and query how they can possibly achieve this at the moment, given the fact that this technology source database from so many different sources, and it might contain inaccurate information. But there might be wiggle room for these service providers to argue that as long as they have taken proper measures, they have fulfilled this requirement. So it's not so much emphasis on the outcome, it's more about what actions that they are taking to try to improve the content generated. And also Article 15 of the law requires the service providers to take actions to optimize the generation model if it turned out that the content that they generate do not meet the requirement of the guidelines. And that again, within a 3-month window. And that again is a very high, very demanding requirement on the service providers. And the one last thing I want to mention is Article 6 of the provision of the draft measures require the generative AI providers to do a security assessment before providing the service. So they need to file a notification with the CAC and conduct this assessment. And that kind of differs from previous AI regulations, such as the regulation on recommendation system and synthesis technology, which only apply to scenarios where the service can potentially mobilize public opinions. Again, this impose a lot of burdens on Chinese AI providers. So I will leave it at that for now, and then we can delve more deeply later.
Great, thank you very much, Angela. So with that, I will turn over to Mark Rotenberg.
Okay, well, thank you so much. And I promise not to talk about the GDPR or data protection. But I do want to take a couple of minutes, if I may, to give you the overview of the global AI policy domain so that we can place the recent developments in China regarding generative AI, talk also about the US response in a broader context. And I do want to share with you as well that we have just published very comprehensive report called the Artificial Intelligence and Democratic Values Index. It runs about 1,200 pages. It's a comparative study of 75 countries, looks at the US, looks at China, goes into detail about several of these topics. I'm just going to briefly overview and then talk about generative AI. So this is a field that has evolved very rapidly. And in 2019, the OECD, leading democratic nations, about 38 in Paris, agreed to 10 principles, the OECD AI principles, growing out of traditional notions of fairness, accountability, transparency, protecting fundamental rights. The US is actually one of the lead participants in the undertaking at the OECD. Now, what's remarkable is just 2 months after the OECD adopts the AI principles, the G20, which includes China, Russia, Brazil, Indonesia, and others, takes a cut and paste and says, we will endorse these principles as well. Now, part of the explanation is that the OECD is serving as secretariat for the G20. G20 wants to say something about AI, and they take this sort of light touch set of principles. But it is a remarkable moment because in 2019, you've already got what I would say is global buy-in from more than 50 countries on a guiding set of AI principles. But there's more, because around the same time, UNESCO undertakes the development of the recommendation on AI ethics. And by 2021, UNESCO has issued, with the support of 193 member states, its framework for AI. Yes? So now we've got 2 global frameworks on the table. Over at the EU, we have the EU AI Act beginning in 2020 with a white paper, moving now to the trilogue likely in the second half of 2023 under the Spanish presidency. That gives us our first legal framework for the regulation of AI, looking very much like, I wasn't going to say it, but the GDPR. And then over at the Council of Europe, we have the 47 member states negotiating the first international treaty for artificial intelligence, which will likely follow shortly after the EU AI Act. The short version of this is a lot has happened in the policy domain very quickly, implicating a lot of countries in terms of the commitments that they are making for what we might call the ground rules for AI. Now, let's talk very briefly about the relationship between US and China with the EU in the middle. China has moved quite quickly over the last several years to put in place regulation. As was mentioned before, they did a GDPR style law called the Personal Information Protection Law in 2021. They followed on with a guideline for the regulation of recommendation algorithms, yes, which actually preceded the current debate we're having over generative AI, which looks, by the way, very much like Article 63 in the DSA. So China is doing a bit of a cut and paste from the EU regulation. And I think this is very much in anticipation of expanding global trade while simultaneously creating a market dominance, something that I hope the US begins to understand, because we don't talk too much about regulation in the US, we just talk about market competition. China, I think, is trying to do both. And now what you see most recently with the recommendation on generative AI is actually the Chinese government, you might say, leapfrogging the US, possibly the EU, in setting out a framework for regulation of this most recent type of AI. And by the way, we are planning to comment on that regulation. It's open for public comment until May 10th, and you can go to our website called The Public Voice. There's opportunity for public comments on many AI regulations. Okay, so where's the US? I've given you the big picture. I've told you about how China is rapidly regulating in the data protection and AI realm. The US was at the front of the line with the OECD AI principles in 2019. and then kind of hung back. The US, for various reasons unrelated to AI, is not a UNESCO member, so did not participate in the development of the recommendation, not in the EU, not working on the EU AI Act. Yes, at the Council of Europe as a non-member state, because non-member states can ratify Council of Europe conventions. But a number of things have happened in just the last several months in the US, which are quite remarkable. So we have in the fall of 2022, the White House Office of Science and Technology Policy finally puts out an AI Bill of Rights. Well, it's not actually a legally binding Bill of Rights, but it does provide the foundation for legislation. January of this year, President Biden publishes an editorial in the Wall Street Journal, says we need bipartisan legislation for the regulation of artificial intelligence. Quite remarkable. And then just a couple of weeks ago, and this is where I'm going to end, Senator Schumer, New York, majority leader, citing recent regulatory developments in China, among other factors, says he will now prioritize AI legislation in the US Senate, right? So now the US is actually trying to catch up with a regulatory activity that's been underway, I would say, steady pace in the EU and accelerating in China. Will there be convergence? I don't know. But keep in mind that in 2019, you had the G20 countries agree on a common framework for AI. It's possible.
Great, thank you very much. Before I hand over to you, Rung, I just want to check that I understood. Did you say that the US is commenting, so the Chinese provision, the regulation is open for comment? Does that mean outside, for
Yes.
people situated outside of China also?
Right. And in our big report, we actually rate countries on 12 metrics, and we create tiers from the top tier of the best countries for AI policy and practices down to the ones that are not at the top. But one of the factors that we consider in our 12 metrics is, has the country given the public a meaningful opportunity to participate in the development of AI policy? And it is notable that the Chinese government has made a point in the last several regulations it's announced to create an opportunity for public comment.
But not just the Chinese public.
Anyone,
Okay.
anyone. And we've submitted comments in the past, and we will in this one.
You're wrong.
Thank you here. I would like to make several points and responding to Mark and Angela respectively. Firstly, I think with this regulation, the measures on generative AI issued by CAC is actually a reflection that CAC is quite informed in this area. There are certain like tokens, the words, like the text used in this measure that specifically refers to the technical points that in the deep, like in the machine learning and also the generative AI framework. For example, it requires the disclosure of the pre-training data and the optimization process. And as introduced by Stein and also like my CS friends, the current machine learning framework is usually composed of 3 different processes. First is the pre-training, and second being the optimization, and third being compression, which does not have like new data fed into the model. So to that point, I think CAC's regulation is actually informed by the industrial like players and also the research institutes in this regime. However, as Angela has mentioned, that the measure seems to impose a very heavy duty to those providing AI products and services, which seems to be in contrast to the strategy policy say that China wants to have a more prosperous and have a leading role in AI and other like high technology areas. So how to explain that? I think the current CAC framework is actually built upon the existing legislations, as mentioned, that there are recommendation algorithm measures, guidelines, and also there are deep fake regulations as to if you are using this technology to change certain figures, picture in a certain things, that you will need to have like watermark or otherwise to mark it and show the users that this might not be authentic. So there are several ways that CAC is actually not creating a very new legislation in this regime. However, just to specify that in the generative AI services, what kind of compliance requirements might need to be reached by the companies. However, this might increase certain kind of like enforcement issues, because according to the in the same line of recommendation algorithm, the logic of CAC's regulation is to say that you need to register and have a security assessment with CAC about your algorithm. However, with these large language models and very complex source code, and especially those like the data's fetching and all these things, if each company would require to submit and register their algorithm to the government, and government is doing the algorithm auditing, it's doubtful to what extent the government will have the capacity to actually do a de facto security assessment instead of like a superficial one just to fulfill certain kind of procedural requirement. Actually, the same thing happens in the more relatively recent regulation about data outbound requirement that requires certain companies that meet a certain threshold of personal data or amount of the total amount of data. Then you will need to file a data outbound assessment to the government. And however, for example, I'm informed by my friends working in Chinese law firms, handling all these new compliance jobs that is created by this legislation, that there are a lot of part of it does not involve very substantive scrutiny from the government side, which I suspect, which is just my speculation, that there is no enough institutional and organizational capacity to conduct the substantive assessment. So what is the future of this kind of measures on generative AI by CAC? As Angela mentioned, the CAC is just one solo department in China regulating cybersecurity and internet-related regimes. However, CAC is quite influential and basically have the dominant position in China regarding those measures. And there is a phenomenon, it's just based on the user experience, and my friends in mainland China helped me test all the channels that they used to be able to register for ChatGPT and Midjourney. Certain channel of it is disabled after the measures draft for comment is issued. So what are the kind of those being regulated by these measures? It's not just the Chinese AI companies that might subject to this kind of scrutiny, but also those who ever provide their services to PRC citizens, that is in the application clause of this measure. So with that, what is the real effect of this measure is questionable. In a way, it might intimidate foreign companies like Microsoft or OpenAI, Google, to provide this kind of service to Chinese citizens to create certain kind of geofencing technologies, or they're just kind of screened out by the firewall. It's speculative. So. And the third thing is I would like to kind of mention is the consensus, responding to the point that there is a growing global trend towards generative AI regulation and a consensus about the basic principles that AI developers should follow, which I agree. However, there might be certain difficulties as to specify the consensus is reached in what kind of level and in what kind of detail. Because, for example, as our afternoon panel have discussed, there are certain supply chains in the AI circumstances, and that supply chain basically refers to who have pre-trained the data set and create that kind of model that would people later use to stack on it. That is one understanding of supply chain. There is other understandings of supply chain. For example, is reflected in the industrial report in China. Last year, there is a research report by Bank of China regarding the development of AI in China. And they basically understand supply chain as everything from hardware to software and its future applications. So in that sense, they basically specify that China does not have certain advantage in the chip. There are 3 types of chips, and only one of them in the emerging new market that Chinese market and companies might be able to catch upon, but the other 2 is greatly fall behind. And also there are certain aspects in the supply chain assessment. Also, as you can refer to, for example, OpenAI and other big tech companies, when they have this kind of large language models, they will have public essays online. You can check what's their technologies and their training mechanisms. However, if you search the public sources, there might not be as many as you saw from Tencent, from Baidu. So there are still, at least in the public domain, there are still a large technical gap or barrier that we need to think about. It's as Angelina said in the afternoon infrastructure panel, the developing countries actually treat data and AI as a way of development, which is a very common phenomenon. And I would like to also reflect on this point in the sense that Chinese market or Chinese regulation view data as a very, they have a very special take of it. They repeatedly emphasize that data as a factor of production, and there are responding infrastructures created based on this. For example, the Eastern computing, Eastern data, Western computing, which is a kind of nationally mobilized way to reallocate the data centers and how the data should be computed and how those models should be trained. So in responding to all these, I think the consensus here, to what extent we do have is a question. For example, the ambassador also mentioned that there is no labor law protection in China, although in the 2019 Beijing consensus issued by certain Chinese research institutes, universities, and industrial alliances in AI, recognize like openness and respect for labor, responsibility, control of risk, this kind of elements taken into consideration. So to what extent like government, industrial players, and the research institute may reach certain consensus, and to what extent in the global regime among governments or among industrial players, they could reach consensus, which is a thing that I'm not certain of.
Great, thank you very much, Yaron. I mean, maybe just to kick off the discussion, if I could ask a very broad level question, given that the topic is coordination and convergence and divergence. So, you know, Mark said that there's an emerging kind of convergence of sorts at a high level of principle with the UNESCO and the OECD guidelines, but Yaron was suggesting, well, that's at a very general level, and that the, you know, formulation of more precise provisions and maybe binding provisions too, as the EU is going to might change that, and the lack of consensus will then become rather more obvious. But it does seem at the moment as though, you know, China is ready to regulate in a particular way with some really distinctive provisions on security and on content and so on. The EU is set to regulate in a very precautionary way, as it generally does. And we don't yet know, and the FTC is doing some regulation of consumer protection and so on, but we don't yet know what the federal regulations will look like in the US. So assuming that there won't be a great deal of convergence in the three major powers or trade powers regulatory models, what are the implications of that in this area of AI? You know, because if I tend to think of, well, what are the implications of regulatory divergence between China, the EU and the US in some conventional product, whether it be hormones or something else, it's access to the market, it's, you know, trade flows. But this seems rather more complex and rather more that there's a lot more at stake in the lack of convergence or in the very different types of regulatory approaches that the different jurisdictions might take. And I wondered if any of you might want to comment on that or maybe try and.
Well, I think I'm going to push back a little bit because I think it is actually in the nature both of the modern global economy and digital technologies that regulations would tend toward convergence. And so then you have to begin to ask the question, what is it that prevents sort of the natural tendency for these frameworks to converge? One concept which we should put on the table to help understand this dynamic, and it's been widely discussed in the GDPR realm, is the Brussels effect. Yes? So Brussels passes a regulation with the explicit goal of regulating the internal market of the EU. And suddenly you see from Saudi Arabia to Argentina to California and Illinois, privacy laws that look like the GDPR. And what people observe, of course, is that the EU is exercising regulatory influence beyond its national borders for straightforward market-based reasons. That's a big market within the EU, but also there's a tendency toward harmonization and standardization in the digital economy. Now, what I think is happening is we're beginning to move beyond the Brussels effect. In one sense, Brussels is hoping to recreate it with the EU AI Act, and they've been explicit about that. They say, wow, look how successful we were with data protection. Let's see if we can pull that off with artificial intelligence. I think China is thinking, how about a Beijing effect? What if we can become a source of regulatory authority, particularly in the countries in the Belt and Road Initiative, where we already have strong trade relations? We exercise regulatory authority beyond our national borders. And the US, frankly, is a bit confused in this moment because the US knows that it has a great deal of market power, but because it's sat on the sidelines of the regulation of the digital economy, it's actually difficult for the US at this moment to exercise much regulatory force. So I think what we're actually seeing right now is not so much divergence. I think we're seeing a bit of a competition over the locus of control of global regulatory authority.
Jeroen or Angela, would you like to come in on that?
Yeah, I would like to add some points here. At the beginning, I mentioned there are some similarities between the Chinese regulation and those that you see elsewhere in terms of the emphasis on protecting data privacy, avoiding violation of IP rights, as well as non-discrimination principles. I do see opportunities for convergence in this area because every single country, including China, have an interest in advancing these goals. If you think about, IP violation, China is an important player in the sphere. China is also producing a lot of patents, right? I mean, so to the extent it is concerned about, AI exploiting the work of original authors from China, it will similarly will have an interest negotiating with other countries that it needs to protect the interests of foreign regional content providers, right? So I do see commercial, business interests in pushing China to converge with other jurisdictions on certain points, like data compliance, because it involves cross-border data transfer. China, again, will have an interest in negotiating with other jurisdictions. Non-discrimination principle, I think there's some universal values shared between China and other countries. regarding non-discrimination. So I do see some opportunities for convergence. But definitely there will be divergence in the sense that because the big emphasis here on CAC's rule, as you see, is on content, and particularly political alignment with the Chinese political values. So this is a point definitely we will see a lot of divergence, and that also explains maybe why Yirong was mentioning earlier, right? I mean, ChatGPT is trying very hard to avoid being subject to CAC rules. So it's now getting more difficult for the Chinese users, even if they use VPN to try and access the OpenAI's service. But I also want to mention one point is Article 2 in the provisions mentioned that this law applies to all service providers providing the service to the Chinese public, right? So clearly how you interpret this provision, because if Microsoft is providing this service to a private Chinese enterprise, query whether that will fall within Article 2 of this provision, which may mean that maybe there are some exceptions to these rules. So a lot remains to be clarified, but I do see both opportunities for convergence, and there could definitely some divergence, yeah.
Certainly. I also echo the point about convergence, but I do have a little bit pushback on this point. I think convergence will be easily happen in the way of in regarding the protection of certain rights. Because for the business, as Angela said, there is a business case for the companies to provide a higher level of protection if that can satisfy the certain jurisdictions requirements, and it will be costly to to fragment their standard of protection between different jurisdictions. That is very true. I echo that point. But the divergence I see could be in the way of obligations upon those actors in the field. In terms of obligations, not only the compliance, for example, the reporting obligations procedurally for each actors in the jurisdiction, but also for the allocation of risks. There is a differences in what all sorts of kind of risk allocations, to what extent which actor in the supply chain should bear the risk to have the level of scrutiny, or who should bear the responsibility for the damage or the harm. So that would be slightly different. And in the ways divergence I see in Chinese regulation towards data or the cyber regime in general, there is an increasing use of jurisdiction as to the fence of data flow, which might be criticized as data localization. To what extent it constitutes, which is subject to certain debate. However, we do see there is a data outbound filing requirement, and a lot of companies do struggling with that, because you will need to do the filings with local government, and local governments is not apparently equipped with the labor, the organizational arrangement to it. As one of my lawyer friends experienced at the very beginning, when that guideline issued, it's barely possible to get their phone calls to the local government to be answered, because they have so many questions as to how to interpret this, how to interpret that, how to fill in each different forms. So that is actually a thing I think is existing. And another divergence that I see might be the way in which government and private big tech companies' relationship. For example, in the 2022 Arliss report on AI, they mentioned that how to make their algorithms, their AI models transparent. The way in which they see it is to deal with two different kinds of relationships. One relationship is to deal with the government, in which they need to comply with all the algorithm auditing requirements. And also there is a action which is kind of called Qinglang action to different big tech companies to require their compliance with to internet content, algorithm recommendation, and all sorts of different things that government might require the big tech to comply with. And another like relationship seen by Arlie is to deal with its relationship with its users. And with its users, they see it's not necessary to disclose the source code because it does not make any sense for the general public to understand what this kind of machine language actually means. Instead, they think it's very proper to add, for example, to explain their algorithm function in the agreement that you need to consent to log in their platform, and also in their like public channels like Weibo and other social medias in China, they will publish certain informations about how their algorithm is supposed to work and their functions. So that is what Arlie see the relationship about like this kind of algorithm and AI regulation towards them. So I think situations might be slightly or bigly different in different jurisdictions as to the this kind of two relationships. So that's also a place I see divergence.
Great, thanks. I'm conscious of time running on. Would you like me to open to maybe we'll take a couple of questions from the floor if there are any. One other, just while I'm waiting, because there are no hands up yet. One other question I had was, I think I read in The Economist this week that unusually for The Economist, they were saying we need an international treaty for the regulation of AI. And your suggestion seemed to be more like this is happening spontaneously through market mechanisms. There's sort of some sort of convergence happening, but they seemed less confident of that.
So if I can add to that point, I mean, there is a part of the conversation which we didn't get to today, but it's probably worth putting on the table. So how many people are familiar with the letter, the Future of Law Institute letter, right? Very controversial, 6-month pause, the, existential threat tech bro letter, right? And then you had, I don't know if Sarah's still here, from her group, AI Now Institute actually writes to the European Commission and says, you've got to be sure to cover generative AI. What's happened in the last couple of months, and this is where the Economist commentary comes from, is that the AI research community, for different reasons, and frankly, deeply divided reasons, has come to the conclusion that we need regulation for AI. And so you see suddenly a lot of proposals, international agencies, international conventions, all of these things coming out from the AI research community. Now, the frustration for us at the Center for AI and Digital Policy is that this is the stuff we've been working on for the last several years with all of the international organizations. And what we're hoping will happen is that all this energy in the AI research community, whether it's the 6-month thing from Elon Musk, or it's the slow AI from Timnit, because she said that 2 years ago, both communities, right? I see people nodding, so thank you. We're in a moment now where we actually could get some regulation, but we need to draw on these policy frameworks that are already underway to get to the finish line.
Okay. I think there's a general fatigue in the room, so it may be time to move towards the food. I'll hand over to Thomas, maybe for the final words.
Yeah, thank you so much. First of all, thank you to Angela for getting up so early in Hong Kong, and for Grania, Yurong, and Mark for giving us a global perspective towards the end of our conference. So that's one round of applause. And then I have 2 more thanks and 1 task. So the task is that there are students here from our Global Tech Law seminar, and believe it or not, they're really used to listening to Stein explaining complex systems, and Benedict thinking infrastructurally, and myself trying to explain European Union regulation at this hour, because our usual class hour is 7 p.m. to 9 p.m. So at the beginning of that seminar, we promised them that one educational outcome of the Global Tech Law seminar would be that they would be able to talk about complex digital infrastructures and their regulation with peers and people who are interested in these topics and maybe potential employers. So now is their chance to show that they have achieved that task that we've set for ourselves and our students. So I encourage all of you who are not students in our Global Tech Law seminar to ask the students in our Global Tech Law seminar about their papers and about their projects and what they've learned in our seminar. So that's the task. The thanks is, of course, to everyone who's made this conference possible, which I've mentioned was organized with an incredibly short time frame. So thanks a lot to all the panelists who said yes at very short notice, to all the students who sat outside signing in and signing out, the CLE, to everyone who made this conference possible, in particular, our team at Guarini Global Law and Tech, Benedict and Angelina, who trusted me in putting this together. Yorong, who, as you've just seen, is a very sharp analytical mind, but also a very capable organizer. Charlotte, who turned a GDPR conference into a generative AI conference, and everyone else at Guarini Global Law and Tech who was part of this. And the final thanks is to everyone else who supplies the infrastructure that makes a law school and this kind of academic educational enterprise possible. So all the technicians that make sure that the cameras work and the mics work, and everyone who brings the food that we now all, I think, need and deserve, to really everyone who participates in this kind of exercise that is supposed to create knowledge and foster discourse. So thanks a lot, and let's enjoy the reception together.